There are 35 offences in New South Wales that currently carry what are called standard non-parole periods. They range from 3 years for unauthorised possession or use of a firearm up to 25 years for murdering a child. The non-parole period is the period of time someone must spend in prison before being eligible to apply to get out of prison. The standard non-parole periods are governed by Section 54 A and B of the Crimes Sentencing Procedure Act of 1999. Section 54 B says that when determining the non-parole period, the court should set the standard non-parole period unless there are reasons for setting a longer or a shorter non-parole period. The meaning of standard non-parole periods was considered in the High Court case of Murdoch versus the Queen in 2011. The High Court in that case said that the standard non-parole period is not a starting point for the sentencing process. Now, previous case law of the New South Wales Court of Criminal Appeal was wrong, the High Court said, to use a two-step process for sentencing in standard non-parole period cases. The New South Wales Court of Criminal Appeal had said that the process is to firstly ask whether the offence falls within the middle range of objective seriousness, and then secondly, are there matters that warrant a decrease or an increase in the standard non-parole period. Now, Murdoch said that the standard non-parole period is a guidepost or a reference point when deciding the appropriate non-parole period for an offence. Just like maximum sentences are guideposts, so are standard non-parole periods, the High Court said. The High Court said, must fully identify the facts, matters, and circumstances that bear upon a sentence that is imposed. And this is regardless of whether the person had pleaded guilty or not guilty, and it's regardless of whether the offence falls within the low, middle, or higher range of objective seriousness. The High Court said that the standard non-parole period is the non-parole period to be imposed for an hypothetical offence that's in the middle range of objective seriousness without regard to aggravating or mitigating features. So, both the maximum penalty and the standard non-parole period are now important legislative guideposts when deciding the non-parole period for an applicable offence.